we hope to have more significant information on our opening plans in the very near future. So I encourage you to stay on top of the news, very specifically on top of the Chamber's website. And as we get current information about what's going to happen at the end of the Indiana stay-at-home order, we'll have that information out to you as quickly as possible. We'll make sure that we keep it accurate, and you can count on having all the details you need for the ways we will begin to reopen our business environment here. As immediately as we have them, you'll have them. But one of the ways we will open our local economy and make it start to come back to more normal, or whatever new normal looks like, is to make sure we've got our plans and our procedures in order. And there has been so much information coming at you from every corner over these past few weeks, particularly with regard to the federal resources that have been made available, that we had overwhelming interest from the business community on the topics that we're going to address today in this webinar. I want to take a moment here to thank the 4 law firms that have come together to organize this 1 hour, and I hope timely use of your day, because they did so out of interest in this community and in making sure that you have the best available information you can. These 4 firms have been stalwarts of the Chamber of Commerce, of the Southwest Indiana Chamber of Commerce is proud to have the chance to host this event today and to bring you insights from excuse me, I'm getting information here, from Farmer Scott, Ozete, Robinson and Schmitt, from Dees, Donovan and Kahn, from Stoll, Keenon, Ogden, and from Ziemer, Stayman, Weitzel, and Shoulders. So our 4 firms that are going to share information with you today are stalwarts of this community, and we're most appreciative of having them. I'll say one more word, then we'll get down to business. The hallmark of the Southwest Indiana Chamber, and certainly what we have been taking full advantage of these past few months, is intentional collaboration. And so when this demand came up, these firms reached out to each other and organized this webinar that you're going to have the opportunity to share with them today, because they knew it was useful to the community, and they have taken our interests and our priorities and made them front and center of what they contribute time to. So I'm deeply appreciative of their taking this responsibility on and sharing it with you today. So thanks for being with us. If you haven't used Zoom before, you are muted. We're doing that because there's hundreds of people on this call. So if you wish to communicate something for me or have a question you think is central to this, please use the chat bubble at the bottom. So you'll see a little thought bubble. If you click on that, it'll open up a chat. I'll watch that chat, and it'll give us a chance to make sure that we get any feedback from you that is pertinent. But without further ado, I'd like to launch us here by introducing my friend, colleague, and a very able attorney in our community, Laura Scott. Laura, would you lead off with us today?
Yes, thank you. Happy to do it, Tara. Thank you to all of you that are joining us. I hope we have some good information for you today. I know this is all very timely information, so I'm looking forward to sharing that with you. Audrey, if you can go to the next slide, please. There's a copy of our agenda for today. These are the topics that my colleagues and I are going to be covering over the course of this next hour. And Audrey, if you can advance to the next one, please. And there's me. I'm going to be talking today about the Families First Coronavirus Response Act. Next slide, please. I'll jump right in because we have a limited amount of time and a lot of material to cover. So this is important information, even if your business is currently closed, because although the act went into effect on April 1 of this year, it continues to be effective through December 31. So even if your business is currently closed or had to close and is looking towards reopening, these are going to be laws that will impact your business throughout the rest of this calendar year. So it's important to know what they mean and how they can affect your employees over the coming months. There's 2 parts to this act, Emergency Paid Sick Leave and Emergency Family Medical Leave Act leave. And I'm going to talk briefly about each of those and what they mean. But first, let's talk about who this act applies to. It applies to private employers with between 1 and 499 employees. It also applies to government workers. It does not apply to private employers with 500 or more employees. It doesn't apply to healthcare providers, to first responders, or to another category of businesses where allowing employees to take this leave would jeopardize the viability of the small business as a going concern. And there's more information and more detail on that exclusion contained in the guidance that's available on the Department of Labor's website. Next slide, please. So let's talk first about the first section of this act, and this is the emergency paid sick leave. If there is an employee that cannot work or telework due to one of 6 COVID-related reasons, then that employee is entitled to up to 80 hours of paid sick leave at their full rate of pay for a maximum of $511 per day. So let's talk about these 6 situations where the act would apply. So the first 3 of these situations apply to circumstances that affect the employee directly. So the first of those is where the employee is unable to work or telework because of a government quarantine order. And that includes stay-at-home orders, just like the orders that are in effect now in Indiana and Kentucky. It also applies to a healthcare provider's advice to self-quarantine to an individual. And that could either be because the person is sick or has been exposed to someone with COVID, or it could be someone who is just a vulnerable population due to their own underlying health concerns. The third circumstance where this kind of sick leave could apply to an employee is one where an employee has COVID symptoms and is seeking a diagnosis. So again, in those 3 circumstances, the employee would be entitled to up to 80 hours of paid sick leave at their regular pay rate, maximum of $511 per day, and an aggregate of $5,110 per day. If you have a part-time employee, then it would be the average hours worked over the prior 2-week period. Okay, so that's the rule for 3 circumstances that apply to the employee directly. The other circumstances cover situations where the employee is caring for someone else. So in the event that you have an employee that can't work or telework because the employee is caring for someone else that is under a government quarantine, or is under a healthcare provider's order to self-quarantine, or the employee is unable to work because they have a son or daughter that is home due to a school or daycare closure, then in those circumstances, the employee is still entitled to up to 80 hours of paid sick leave, but the rate is reduced. They get paid at 2/3 of their regular rate with a maximum aggregate of $200 per day. Maximum $200 per day with an aggregate of $2,000. Same applies for part-time employees. It's their average hours worked over the prior 2-week period. Now, let me be clear about a couple of things that I've just said. Just because the Act talks about somebody's inability to telework, this does not obligate an employer to allow somebody to telework. So if you have the kind of business that just doesn't lend itself to teleworking, this act doesn't mean that you have to allow your employees to now begin working remotely if that's something that you just aren't set up for or don't think is appropriate for your business. But it does say that if you do have telework capabilities and you are allowing employees to telework, if they are unable to telework because of one of these circumstances, then they would be entitled to the emergency paid sick leave. An employer does not have to pay out unused leave at the end of the year. So if the employee does not use this emergency paid sick leave by December 31 of this year, it is not owed to them after that time. It doesn't carry over to 2021. If the employee is terminated before using their emergency paid sick leave, you don't have to pay it out to them. If an employee had to take time off prior to April 1 because of one of these circumstances, this law is not retroactive. So they aren't entitled to get paid retroactively for days that they had to take off prior to April 1. Also, if there's more than one situation that comes up for an employee between now, or April and the end of the year, they only get one bite at the apple. So they only get one 10-day emergency paid sick leave period under this act. They aren't entitled to get multiple emergency paid sick leaves if they have multiple different circumstances that arise. Let's talk now about the second part of the Families First Act. This is the Emergency Family Medical Leave Act portion. This also applies to someone who can't work or telework, but this is only limited to the circumstance where they are caring for a son or daughter that is home due to a school or daycare closure. And in this situation, the employee is entitled to 12 weeks of leave. The employee can take the first 2 weeks of that leave either unpaid, or they can choose to take their 10 days of emergency paid sick leave in order to get paid during that period of time. But then they are required to be paid for the remainder of that 10-week period at 2/3 of their regular rate of pay for a maximum of $200 per day, a max aggregate of $10,000. So if an employee is taking time off due to a school or daycare closure, staying home with their son or daughter, they could potentially be off for 12 weeks, be paid the first 2 weeks under emergency paid sick leave, the remainder of the 10 weeks under Emergency Family Medical Leave Act, and could be paid a total of $12,000 paid sick leave for that time. All right, next slide, please. Briefly, I want to cover what happens if the employer is already offering paid time off to their employees. Do they also have to offer the emergency paid sick leave if there's already something else available? The answer is yes, they still have to offer the emergency paid sick leave in addition to any other leave time that's already available to the employees. So this is an additional 10 days of paid sick leave, regardless of whatever other paid time off the employer still has. You can't require your employees to use paid time off before using your the emergency paid sick leave. If the employee is entitled to the emergency paid sick leave, then they have the option to either use the employer's paid time off or the emergency paid sick leave. If the employer and the employee agree, the employer can allow the employee to use emergency paid sick leave to supplement any paid time off, or vice versa. So you can use paid time off to supplement the emergency paid sick leave pay that you're being given, particularly if you're being paid at 2/3 of your regular rate. An employee may wish to use that paid time off to supplement that so that they can maintain their regular pay rate. But again, that has to be upon agreement between the employer and the employee before that can be used. The employer can require paid time off and the Emergency Family Medical Leave Act leave to be used simultaneously. So if an employer is looking to shorten the window of time where an employee is out of the office, they can require those two to run simultaneously, but the law says that you do have to pay the employee for both. So they would be paid both their regular rate of pay under paid time off and also the 2/3 rate that they're entitled to be paid under the EFMLA. Next slide, please. Okay, I want to make sure that we also cover what responsibilities the employer has during this time to make sure that they are both notifying their employees of this paid time off that's available, and also what documentation responsibilities employers need. So first, the notice requirement. As of April 1st, all employers were required to give notice to their employees of these additional rights. That notice can be found at the DOL website. It's free, so there's no need for you to pay a third-party service to print posters or provide posters. And those can be either emailed to employees, or if you have a physical work site that's actually still open, you can post it in your workplace, or it could be mailed to employees if they are not currently in the office. So as long as you're getting that notice out to employees, that should satisfy the employer's notice requirement. The other thing that employers need to make sure that they're doing is keeping the proper documentation to substantiate this leave that's being taken, either under emergency paid sick leave or under emergency FMLA. Because in order to claim the credit, which we'll talk about in just a minute, the employer will need to make sure that they have proper documentation. So one thing that I would recommend is that employers get a written statement of leave from their employees. It should have the employee's name, the reason for the leave, a statement that they can't work or telework because of one of the 6 COVID-related reasons that I mentioned earlier, or that they're staying home with a son or daughter due to a school or daycare closure, and the dates they are requesting leave. If the employee is requesting the leave because of a stay-at-home or government quarantine order, then that should be noted in the employer's documentation where that order originated from, and maybe also include a copy of the order. If it's due to a self-quarantine from a doctor, at a minimum, the employee needs to provide the doctor's name, and ideally would need to provide a doctor's note further supporting that leave. Again, if the employee has symptoms and is seeking medical treatment, again, a doctor's note or at least a note of where the employee was seeking the healthcare treatment. And if the employee is seeking the leave because of a school or daycare closure, the name of the school or daycare that is closed. And if the employer could further support that with either a notice from the newspaper or the school's website or an email or something showing that that school or daycare facility is closed, that would be additional documentation that would be helpful and possibly required in order to substantiate that. In addition to information that the employer needs to keep to support the leave, the employer also needs to be aware of Form 7200, which is information that it will need to claim the tax credit for these wages that it is paying for emergency paid sick leave and emergency FMLA leave. And they also need to, employers also need to make sure that you are showing your calculation of wages. So whether or not the employee is being paid at 2/3 rate or whether the rate of time, all of that needs to be documented. Next slide, please. So employers are going to pay for all of this through tax credits. My colleagues are going to be talking about that a little bit later, so I won't dwell on that now. And what about self-employed individuals? Well, good news, they should be entitled to the same benefits and the same tax credits. Hopefully everybody should be covered if there is a need for these individuals to take either emergency paid sick leave or emergency FMLA leave. Next slide, please. All right, that ends my presentation. The good news is if these are the kinds of topics and kinds of concerns that you're worried about, it means that you have employees that you're keeping employed, and that's good. In order to keep those people employed, it also means that you may be concerned about getting a PPP loan, a paycheck protection loan. And next up is Jean Blanton, a partner with Ziemer, Stayman, Weitzel Shoulders. And she and her colleague, Sarah Hardy, are going to be talking more about PPP loans. So Jean, it's up to you.
Thank you, Laura. And actually, if you had hoped to receive funds under the Paycheck Protection Program, it's probably too late if you haven't already applied for them. We expect actually the funds will likely be exhausted again today, which is the second batch of funds that have been funded by the federal government. But really our focus today is more prone to the forgivability of the loans you received, the necessity representation you made in the process, and a lot of what has hit the news as of late that has caused a lot of anxiety and concern by those who have received the proceeds. So we're going to address some of those topics. And I'm going to start out by analyzing the purpose of the loan, which I think will be important for everyone to remember as they determine whether or not they meet the parameters. As you likely know, the federal government committed $659 billion in forgivable loans to small businesses under the Paycheck Protection Program. And that is part of the Coronavirus Aid, Relief, and Economic Stability Act, otherwise known as the CARES Act. It's a massive program that was very quickly rolled out with very minimal supervision and very little review of the loan applications and very little guidance. In fact, we're just now starting to see guidance roll out slowly, and that I think is what is causing a little bit of the uproar. The most recent information is that every PPP loan of more than $2 million will be audited. But we're also hearing rumors that some of our elected officials at the federal level are saying that all will be audited. Now, there are a lot of people that have taken these loans. I don't know how conceptually they could audit all of them, but we should all be prepared that that will be the case. The government is getting very serious about making sure that the funds are not being abused, and that is particularly true after we've seen significant media coverage of loans that have issued to large profitable businesses. It's caught the attention of many people, and that is causing additional scrutiny. However, we need to all recall that the immediate objective of the program was to inject a large amount of money into the economy quickly. Basically, we wanted to keep people employed, keep the doors open, and keep the lights on. Our banks, including those of our local banks, have been very overwhelmed with this program. They're oftentimes dealing with thousands of applications and a lot of pressure to get the applications turned around before the money runs out. The first batch was $349 billion, and it was allocated in just 2 weeks. Most people expected the second batch to go much faster than it has, but as I mentioned, we're hearing projections that the funds will run out today, and that is another $310 billion. We know our local banks have been working long days for all of us. They've been doing a good job, but we want to talk now about those of you who have received the funding. How can you use it? Okay, so that's the very first topic we're talking about, or use of the proceeds, and you'll see these other topics will be covered. I'll cover forgiveness, and then the remainder of the topics will be covered by my partner, Sarah Hardy. Next slide, please. Okay, so on your slide now, you can see the various methods or various categories for which you can use the proceeds of these loans. These categories that are listed are very specific. You cannot utilize the proceeds for any other purpose other than those that are identified for you here. However, when we talk about payroll costs, those costs include costs relating to continuation of group health care benefits during periods of paid sick, medical, or family leave, as well as your insurance premiums. Okay. Now, you also need to know that if you utilize the proceeds for purposes other than those for which they're approved that are listed here, then you can be subject to fraud or other charges. Okay, so it's very important to make sure you're utilizing the proceeds for the appropriate reasons and that you've documented that and have records to show what the proceeds were utilized for. There are no payments required in the first 6 months after receiving the proceeds, but to the extent it's not forgiven, interest will be accruing during that 6-month period. Next slide, please. Now, as I stated there, you'll see this language here. The amount the borrower spent on those covered expenses we just went over, other than number 6, okay? You'll see here, number 6 is not listed because it is not to be forgiven. So the refinancing of the SBA economic injury disaster loans are not subject to forgiveness, but these other 5 categories are. With respect to that, however, 75% of the amount spent total must be on your payroll costs, so on number 1. With respect to the SBA economic injury disaster loan, which is not subject to forgiveness, those are refinanced at 1%. So there's still a help there for you as well, even though it's not to be forgiven. And we're going to switch gears here now, and the next part of the presentation is to be led by my partner, Sarah Hardy, and it addresses the issues that will apply somewhat differently to each borrower. So it's important that you contact your legal counsel that is up to speed on these issues. If your legal counsel is not up to speed on those issues, you need to seek someone who is, particularly with respect to the issue of the economic necessity representation that each borrower made at the time they submitted the loan application. And Sarah will address that in a couple of minutes. Sarah?
Thanks, Jean. These next couple of topics are the topics that we're really starting to see a lot of questions on at our firm. They are in forefront of everybody's mind. All the folks who have their PPP loans, they want to know how it's forgiven. They also want to know are they going to get in trouble because they got one, and do they really need that loan? So that's what we're trying to address here today. Jean talked about how you maximize the amount that you can get forgiven. That is during that 8-week period, and that 8-week period actually starts the day you get your money. You can't do anything to push that date off any further. So during that 8-week period, you can spend it on those topics and get whatever amount you're eligible for forgiveness. However, there are several ways that that eligible amount can be reduced. There are basically 4 ways. The first is if you spend less than 75% on payroll costs, then that'll be dollar for dollar off the top of the amount that could be forgiven. If you've spent money on things that are other than those covered expenses, that list of 5 that were covered expenses, once again, dollar for dollar, they'll take it right off the top of the amount that you're allowed to be forgiven. There are 2 other areas, one that has been called basically the headcount reduction, and the other one is a wage and salary reduction. The headcount reduction is kind of a formula. You basically take your total full-time employee equivalent headcount during the 8-week period that this forgiveness applies to, and you compare that to one of 2 periods of time, either February 15th through January 30th of 2019, last year, or January 1 through February 29th of 2020, this year. The borrower gets to pick which one of these works better for them, so you should obviously calculate both of them to see which one works better for you and choose that one, and then you could compare those 2 periods, the 8-week period and then one of those 2 periods. You'll come up with a ratio. That ratio or percentage will be applied then to the total eligible amount of your forgiveness. So if, for example, your head count during that 8-week period reduced by 5%, then you would only be entitled to 95% of whatever that total eligible amount was. So that's the first reduction. The second reduction is the wage and salary. You look at the wages and salaries that were paid during that 8-week period. If they are reduced by more than 25%, so the first 25% is kind of a freebie, but anything over and above that 25% compared to the most recent full quarter that this particular employee worked. So this is based on each employee, not basically overall. So we're looking at comparing the 8 weeks to the first quarter of 2020, and anything that is more than a 25% reduction is going to cause a dollar for dollar reduction in the amount of the forgiveness. You don't include in that salary calculation anybody who's making over $100,000. So it's just the folks making under $100,000, and it's dollar for dollar. So if XYZ employee, whoever that might be, is making X amount and it's then reduced by 30%, then that 5% is all you're going to look at in terms of the dollar for dollar reduction. As if that's not complicated enough, there are now ways that you can also eliminate that reduction. Next slide, please. Next slide. So basically this is requiring you to bring back employees or restore their wages to certain levels if you want to eliminate that reduction. So by June 30th, 2020, you can increase your full-time equivalent for your employee headcount to pre-February 15th, 2020 levels. And if you do so, then that headcount reduction will be eliminated. If by June 30, 2020, you restore the wages and salaries to a level of more than that 25% reduction, so it can still have the 25% reduction, you just get rid of that excess, then that wage and salary reduction will be excused as well. This is going to be different for every company. There are all kinds of issues that will come into play. It's not kind of a one-size-fits-all. Some people are going to have seasonal workforce that this will affect differently. You're going to have employees that aren't going to want to come back to work because maybe they're making more on unemployment right now, and you're going to have all kinds of issues. So all of this will also dovetail in with a lot of the labor and employment things that are being discussed as well. So once again, you need to contact your lawyers to try and help you get through some of these issues. Next slide, please. And then one more, please. Oh, no, I'm sorry. You were right. Applying for forgiveness. You had it there. The applications have to be submitted to your lender, just like the application for the loan. You go directly to your lender. I have not seen the form for this application yet, but I'm sure that they will provide something in the very near future. They've got about 8 weeks to get that done because people have had their loans for a while. Listed here are several of the things that you may want to be putting aside to help you with the documentation that you're going to need for that payroll, the PPP loan documentation. It's very important that you be able to prove exactly where this money was spent. Some folks are opening separate accounts just so that they can show that. Others are just making entries on their accounting systems in separate accounts so that they can control it that way. But it's very important that you can document meticulously where all this money went so that you don't have any problems. Once you make your application, your lender has 60 days to determine whether or not the full amount will be forgiven. So start keeping all that documentation right now so that when the time comes, you can get that ball started as quickly as possible so that you'll know that it can be forgiven. Once the forgiveness is determined, then you're going to possibly have funds left over in this loan. Some people will be able to completely maximize it and use all the money for the covered expenses, but some of the folks will have some left over. Those monies are accruing interest this whole time, so you can either pay them back if you don't want to keep paying payroll expenses with loan money, that type of thing. You're able to pay it back. You will only incur a little bit of interest up to that point. Or you can keep using that money to continue to pay those covered expenses. It's 1% interest, very low interest rate, so that could be helpful to a lot of people who are having a cash crunch. So you've got those two options. Once the forgiveness amount is determined, they will recalculate your loan and let you know what your payment would be for the next 18 months once payments start up. And so you can continue to pay on it and use that money if you so desire to continue paying covered expenses. The last item that I want to talk about is the economic necessity representation. And this has got a lot of people worried these days. When the PPP loan came out, they made it very clear that you didn't have to prove that you had actually had damage, and you didn't have to prove that you didn't have access to capital. Those are typically things you have to prove to get an SBA EIDL loan, an economic injury disaster loan. But they made it clear that that was not going to be the case here. And then after everybody gets their loans, the government says, oh, well, maybe we better rethink that a little bit because people are going to get a lot of forgiveness and maybe they didn't really need the loan. When you made your application, you had to make this statement, a representation to the SBA, that current economic uncertainty makes this loan request necessary to support the ongoing operations of the applicant. It's really not a very specific representation. It's talking about things like uncertainty, necessity. There's no guidance really whatsoever with what constitutes uncertainty and necessity in these situations. It's going to be different for every single borrower. There are a lot of categories of necessity that you can start thinking about, but I recommend that you start documenting everything that made you think that you really were going to need to get this loan. You need to have a file that has, we were talking about all of these things, and these are the reasons we got this loan, because they're going to look at this. Anything over $2 million is, according to Steve Mnuchin, is definitely going to be audited. as Jean said, any of them could be audited. So they're going to come back and look at this. If you think about Ruth's Chris Steakhouse and some of those folks, they're paying them back because they decided, for the most part, that even though they qualified for the loan under what they thought were the requirements originally, I think the PR for them was just too much, that they decided that it was something that they were not willing to keep. If you make the decision that you really didn't have the need, or you shouldn't have gotten this loan to begin with, then I think that you have until May 7th to turn it back in, no questions asked. So if really things have been going, way better than expected, suddenly you're doing really, really well, and you really, turns out you didn't need this money, you still can turn it back in, and it's done, and it's as if you made that representation in good faith. The problem you have is if the representation is false, it's a false claim to the SBA. There are criminal penalties, there are monetary penalties, there could be treble damages because of fraud. There are all kinds of bad things that can happen if that's the case, and that's what's got everybody worried. So I really recommend that you contact either your attorneys, or in some cases it's going to be an accountant who can help you go through your books and records and understand your need. But that's, I think, all we have for you on those topics today. So next slide. Chris Wisher of Stoll, Keenon and Ogden, and Ted Ziemer of Stoll, Keenon and Ogden will be talking to you about legal and business considerations as the economy reopens. Thanks.
Hi, this is Chris Wisher with Stoll, Keenon, Ogden. Thanks, Sarah, for the introduction. Speaking with me is Ted Ziemer, my partner at Stoll, Keenon, and Ted is on our COVID-19 response team and our SBA PPP task force. And Ted's going to drill down into a little more detail in a minute, but first I want to take a bit to bring us kind of back to 20,000 feet and talk a little bit about this topsy-turvy, upside-down world that we're all living in. I feel privileged that we are in a business as lawyers where we get to keep working, even though a lot of us are working at home. We get to continue to make our living and do what we do, and a lot of people frankly aren't so lucky. So we have some people that right now we're all working under these work orders, stay-at-home orders that differentiate between essential and non-essential businesses. There are different rules obviously for each. As we start to phase in the economy and bring people back to work, that's going to create a lot of questions for folks about how to do that. What are the requirements? And so we kind of want to talk about some of those considerations. I wish I could tell you that we have all the answers, with maybe some of the answers, but we're not going to have all the answers because it's an ever-changing landscape. And I'm frankly sitting here, I feel like I'm at the MLB trade deadline refreshing my Twitter, trying to see if Holcomb said anything at his 1:30 press conference, but he hasn't. And it looks like we won't know till tomorrow exactly what he's going to do. It's likely that it'll look something like what Kentucky, Ohio, others have done with some phased-in approach, but right now we don't have a lot of detail. So if we go to the next slide, the framework we're looking at, there's a lot of guidance from the federal level, state level. We have the Opening Up America Again, which is the federal guidance, and the federal government has issued guidance to all the states, and it's really the states that individually are going to, direct, I guess, what the rules are going to be for reopening in each state. Our Governor Holcomb has announced that he's working somewhat in consortium with some other regional governors to come up with a plan. But again, we don't know exactly what that's going to look like yet. But we're probably looking at a phased approach. It's going to be very data driven. There's going to be, certain amount of different. Right, I can tell you that Kentucky has indicated that May 11, certain industries like manufacturing, construction, professional services, horse racing, but without fans, and dog grooming and boarding would be allowed open. May 20th, retail, houses of worship, May 25, social gatherings of up to 10, barbers, salons, and other similar businesses. So we expect something similar in Indiana, but we have no idea exactly what that's going to look like. This is all going to come with restrictions and rules that are going to be based on CDC guidelines and other things like social distancing, hygiene, limiting number and spaces. And so as you begin to open your businesses, as you begin to bring people back, you're going to have to be mindful of those guidance, and you're going to have to be able to distinguish what are guidance and what are requirements. A lot of what's being put out is going to be mandatory, and some may be more of a guideline, and it'll be important. But I also want to give, it's not on the page here, but the city of Evansville has a really nice website. They've got a task force devoted to bringing Evansville back into the economy. So reopenevansville.com is a great place to go. A lot of this guidance, the federal guidance, the Indiana executive orders are all there. But this is going to be an industry by industry, business by business calculation we're all going to have to make. And I know if most of you are like us, you're chomping at the bit to get back in. I know my wife is ready to send me back in. Next slide. So these are just some general questions, again, trying to stay kind of at the top level here. But these questions are questions that we hear from our clients who are in the same situations that you all are. But frankly, we bat them around ourselves because we're in business too. We're trying to figure these things out for ourselves. But, you know, the things that you're going to be looking at are, how are you going to bring people back to work? Is it going to be all at once, or is it going to be gradual? I can tell you that we have 80% of our lawyers working at home. We think we're going to have a phased approach. We're trying to identify folks that for whatever reason can easily work from home, should work from home, or more in the high risk categories or something like that. They'll continue to work from home, but it's going to depend on your business. Social distancing is going to be key. I don't think there's going to be any circumstance where, you know, you're not going to have to figure out how to deal with at least 6 foot of space between folks. Even in manufacturing, you see the news on the meat packing plants and everything, as far as, you know, how do you design your systems and your processes to where you can have people not shoulder to shoulder. I already mentioned teleworking, but that's a big question. You know, do you have the technology? Hopefully everybody's somewhat in that path now. That's good, because you may need to keep doing some of that. We can go on to the next slide. Masks. There's some different states and maybe different rules, but a lot of the guidance that's coming out now is suggesting that we should all be wearing masks when we're in public and when we're around other people, because this is, even people who are asymptomatic, if they have it, can transmit the disease. So in our workplaces, with our customers, with you know, our staff, you know, if you're in, some of what I've seen from Ohio, I think it was, suggested that if you're not inside your office alone, you should be wearing a mask. So that's going to require, you know, you need to be thinking about going out and getting a supply of masks. There are a lot of folks out there making them. They're out there to be had, but you got to be able to go find them. You're going to have to come up with some plans for how you're going to deal with folks that get sick, you know, or need the sick time, as Laura was talking about. All of those things are in play. So have you think through, as you're bringing people back and as you get your workforce going, you're gonna have to navigate some of those issues. It'd be nice to get out ahead of that. Next slide. So Ted's gonna talk a little bit about some details as far as some employment law and legal considerations. And then I'll wrap up with a few more considerations before we move on.
Thanks, Chris. Yeah, to continue with some of the topics Chris was talking about, as we move to reopen our economy, reopen, you know, back to work, back to business in Indiana, it's important for employers to become very familiar with the CDC and OSHA guidelines. They're coming out fast and furious, and you really need to stay on top of them. Chris touched on several of these, but when we are back into the workplace, social distancing is going to be hugely emphasized, limiting group interactions to small groups. Likely common areas will need to be closed anywhere where groups congregate. If you do have a type of business where face-to-face interaction is unavoidable, installing plexiglass may be something you need to look into doing. Also, personal protective equipment. Hopefully, most people have things already. If you don't have a mask or gloves, or you've got an employee who doesn't have access to it or doesn't know where to get it, you may need to provide those to your employees. And as we come back to work and we make the decisions, on this phased approach, who comes back when, it's important that the criteria you look at to determine who comes back and when is a neutral and business-based criteria, and not, well, it needs to be the same across the board. However, it is okay to allow groups to voluntarily let you know that they feel like they are in a protected group, either because of their age or they have an underlying health condition, and you need to take those things into consideration as well. Another thing that's going to be big to keep in mind is there are things that maybe used to be a no-no for an employer to do. The EEOC is now allowing. For instance, you can require your employees to let you know certainly if they've been tested positive for COVID-19, but even if they have any symptoms, you also can now, I say employers can now require temperature be taken of their employees as they're coming into the office or the workplace in the morning or whenever their shift begins. The threshold I've been seeing is 100.4 degrees. If you are at that level or higher, you can tell them to go home. Next slide, please. You can also make employment decisions based on COVID-19. You can require a test after you've made someone an offer for employment. You can either delay or rescind an offer of employment if a test comes back positive. As I said, you can even, obviously you can send employees home if they have any symptoms, really whatsoever. So the restrictions have very much been loosened in light of everything, this new normal that we're all living with. To touch on something that Laura Scott said earlier, this leave is still available for the rest of the year. So you need to keep mindful of that, both the Emergency Paid Sick Leave Act and the extended FMLA under the Family First Cares Act. If people need leave for the reasons that Laura discussed earlier, you need to provide that. You also need to be mindful of just regular FMLA leave. The ADA, Americans with Disabilities Act, also requires that you make reasonable accommodations to employees. Now, the EEOC has said that you can look at this new normal, both economic conditions that we are now facing because of COVID-19, when you are making the determination of what those reasonable accommodations are, but you still need to make them just as we did before COVID-19. And one of those might be if they've exhausted all of their paid leave, yet they still have a reason where they feel they need to be at home, you may need to, in some cases, offer extended unpaid leave. The last point on this slide is just, if you do have a business that's subject to a collective bargaining agreement, or if you're a part of a union, you need to be mindful of that those terms and conditions still apply, and think about how that works with these new guidelines that we're all kind of wrapping our minds around on a daily basis. If I could leave you, or if you could take anything away from this, you just need to stay on top of everything, because the conditions are changing daily. The guidelines and guidance that's coming down is new day to day, and it's sometimes hour to hour. And you just really need to stay on top of it. Now I'm going to piggyback real quick on something Sarah Hardy discussed. There's still a ton of gray area, and that's why you need to stay on top of this. Like, for instance, we know which categories are forgivable under the PPP loans, but there are areas where we just still need further guidance, like rent. We know rent is forgivable, but it's not yet been determined if rent will include CAM charges, insurance that's rolled into a triple net lease. That rent has not yet been defined. So we just really need to stay on top of that as the SBA offers more guidelines as we go along. Another issue, the SBA has said forgivable amounts are for costs incurred and payments made during your 8-week period. Well, what happens for, you've got utilities or something where the cost was incurred during your 8-week period, but you don't actually make the payment until after the 8 week, even though it was for something that occurred during the 8 weeks. So there's just a lot of gray area, and I encourage everyone to stay on top of it. Keep communication with your banker who helped you with the application. Excuse me, your accountant, your attorney, your trusted advisors, and we'll all get through this together. Chris, hand it back to you.
Yeah, and one more slide, I think, for us. So as Ted said, be prepared, be patient, be knowledgeable, know what, best you can, know what's out there, what the rules are. They change, but it's a marathon, not a sprint. We're at the beginning of the game here in a way, and be prepared for business shocks that may come as we go. There's not going to be a switch that's going to be flipped, and this is all going to be back to business as usual. There's still going to be disruptions. We could have, what if we have a spike in another wave of the disease? What if somebody in your office or in your company, factory gets sick, and then what do you have to do there? Now, hopefully this period of being shut down, this period of being at home we can pivot pretty quickly and deal with those issues. We've learned a lot during this time, and we come out of this thing, I think, better than we went in. Respecting your customer and employees. There's a couple of things going on here. A lot of what's been put in place, the stay-at-home orders, are to bend the curve to make sure that our hospitals can take care of and be prepared for this disease. At the same time, and it's similar but a different item we're looking at, is how do we keep our people, how do we keep our customers safe on a micro level? So understand that you're going to have customers who are going to have different sensitivities and employees with different sensitivities. Connect with your peers. No better time than to have these virtual meetings and get connected with the people in your business, people that you would look at as competitors, but you're not on an island. Don't do this. We have gained so much from being able to talk to our peers here and colleagues in the legal industry. We learn a lot from our clients about how to do our own businesses. So don't think you're on an island. Get consultation from your peers, your advisors, your accountants. I can't forget your attorneys. And then finally, as you go through this, I'll just leave you with this. Just as long as you're practical, reasonable, thoughtful, fair, and kind, I think you're going to be fine. So let's all be patient. Let's work through this together. And then I can turn it over. I think Mark McAnulty is going to give into some more detail on furloughs and teleworking pitfalls. Take it away, Mark.
Did we lose Mark? Audrey?
He's there.
Hey, can you hear me now?
Yeah, there you go.
Sorry about that. So I wanted to start off with giving everybody a little bit of friendly, non-legal advice. If you're married to a germaphobe like I am, which is not a bad thing right now, under no circumstances allow them to watch a movie that came out about 7 years ago called Contagion. If the title alone doesn't scare you off, then just trust me, don't allow it, because you'll probably never be released from your basement office if you do so. So I'm going to talk about furloughs. In my 25 years or so of practicing law, I've heard the term furlough used more in the past month than I have in those 25 years combined. So there's no real legal definition of that term. I'll give you my definition real quick. A furlough is a finite period of time in which employees temporarily cease performing services, sometimes called a temporary layoff. The key is that there is no termination of the employment relationship. So how do you get started? What's the plan? A furlough is as unique as a fingerprint, okay? You have to give some thought about this. You should put it in writing. You have to think about, will employees have consecutive days or weeks or months off? Will you have rolling layoffs where they're off for a week or 2 weeks and then they're back on for another week or so? Maybe they'll be off duty for designated weeks each month or a designated day each week. You have to tailor it to your business and your needs. If you're a larger employer, you may already have pre-existing policies for temporary layoffs and you should consult them. If the existing plan doesn't work for you, you can amend that. Just communicate those changes to the employees when you begin the furlough. The bottom line is have a written plan. It can help you avoid legal issues later. Who's going to be furloughed? Ted talked a little bit about this. Choose employees based on clearly defined criteria and document the business reasons for choosing those employees, especially, this is important, especially if you're only going to furlough a certain group of workers as opposed to an entire department or a workforce. So focus on uniform, objective factors that can be applied across your workforce. The standard, of course, has to be who has the skills you need to continue to provide services and which will cause the least disruption to your business. Think about, are there employees you can furlough that with little chance of blowback on you later? Ask for volunteers. Do you have probationary employees? Do you have your regular employees with the least seniority? If you can furlough those employees first, then that's going to reduce your liability later. Bottom line, do your best to ensure that any involuntary furlough does not have a disparate impact on a certain group of protected employees. What are your employees going to receive and who's going to pay for it during the furlough? You need to determine what you have to provide under your policies or decide what you want to provide and are able to do so financially. Most employers I've spoken to the past few weeks are trying to continue to pay for their employers' health plans if the health plan allows that. If you're not going to keep them on your health plan, then remember you have or may have COBRA notifications, and can you pay for the employee share of the COBRA premium? Some employers are doing that. If the employee is still going to be, if you're going to keep them on your health insurance plan and they're still going to be responsible for their share of the premiums, you have to decide how that's going to be covered. For those of you who are covered by the Family and Medical Leave Act, you have this issue often when employees go on unpaid family and medical leave. You have to maintain their health insurance and you have to figure out a way to recover the employee share of premiums later. You may need to amend your policies or your benefit plans to change any hours worked requirement, because obviously these employees aren't going to be working hours. And again, if you have to do that, communicate those changes to the employee. Who do you have to warn? Many of you probably have heard of the Federal WARN Act, the Worker Adjustment and Retraining Notification Act. Generally, you have to give 60 days notice to employees and to the state if you reduce the hours or if there's a loss of employment, usually for 50 or more workers at a single location in any 6-month period. Now, right, at least early on, we weren't looking at a 6-month period, so many employers weren't concerned about that. But as we go on, as we go through staged reopenings, if you're going to approach that 6-month limit, talk to your attorney to see if you have to give that notice. If you happen to have operations in Illinois, Illinois has its own version of the WARN Act. Indiana, Kentucky does not, but you need to remember that as well. Next slide, please. So implementation. Again, this is going to be unique to your business. You should provide written communication, of course. I've seen many furlough plans that are in a frequently asked question format, which is pretty effective. But at a minimum, you should try to inform employees about everything that you see on the slide. How long is the furlough going to last? You may want to allow for the possibility that the furlough may be extended, but if you can give a definite end date, that's the best recommendation. If you're going to a reduced schedule kind of situation, then make sure that that's clearly communicated to the employees that that covers. Again, if you have any change in company policies that have to be made because of the furlough, now's the time to communicate it to the employees so they can't come back later and say, hey, you didn't follow this policy. That'll pay off in the long run. Communicate to them what kind of benefits they may be expected to receive. You may want to inform them of their unemployment rights, which they have unemployment benefits available to them. Of course, with the CARES Act, which increased the unemployment benefits, many employees are making more by collecting unemployment. Usually the Families First paid leave that Laura Scott talked about earlier would not be available to these employees while they're on furlough. Identify, of course, a contact person that can answer questions. Make sure and inform your furloughed employees that they are not permitted to perform any unauthorized work while they're on furlough.
And that would be the day.
Hourly employees, of course, are going to have to be paid for any time worked. And you need to have we'll talk a little bit later about timekeeping responsibilities. For exempt employees that are furloughed, if you can, furlough them 1 work week at a time. If they perform any work during the work week, you're going to have to pay them for that entire work week. Now, you can also have a furlough where you reduce a salary of salaried employees. Probably this came up a lot back in 2008 during the Great Recession. That's allowable. Make sure you don't reduce it below the salary level requirement, which is currently $684 a week. If you dip their salary below that, they're not going to be salaried anymore, and they'll be entitled to overtime. And again, real quick, during this time when people are on furlough, remember to remind them of any obligations they have to keep your proprietary information confidential. You may want to even think about having them sign a non-disclosure agreement, because while they're off on furlough, are they going to be looking for other employment because of the uncertain times? And you want to make sure you protect your confidential information. Next slide, please. So again, what's the plan for getting back to work? Chris Wisher mentioned some of the recommendations by the government as we start to try to get back to work. You may want to think about encouraging teleworking. Can you return to work in stages? Can you offer special accommodations to perhaps employees who are part of the most vulnerable population? Maybe they have pre-existing conditions that if they contract COVID, it would be much worse for them than the normal person. Who returns, when, what, and do they have to? Again, much of this is going to be driven by the needs of your business. But again, if possible, you may want to ask for volunteers as you begin this reopening your business. Volunteers are usually the kind of employee that are less likely to cause issues as you begin to reopen and begin to maybe experiment with new social distancing requirements and the other things that we're going to talk about a little bit later that workforces are going to have to implement. What if you decide to allow younger workers to come back before older workers, because older workers are more vulnerable perhaps to infection? You could be looking at a possible discrimination claim there. What if you return non-pregnant employees before you do pregnant employees? Again, you may have a pregnancy bias claim there. As Ted mentioned earlier, you need to return employees on a legitimate, non-discriminatory basis to avoid those kind of claims. On the other hand, you may have employees, let's say you have an employee with asthma who is in the more vulnerable population. When they return, they may be requesting accommodations, and you should also consider those to remain compliant with the Americans with Disabilities Act.
It kills us on the PPP loan, because I understand why my people are like, well,
if you ask, if you start bringing people back, they generally cannot, if they have a fear of contracting COVID, that alone is not a sufficient reason to stay off of work. But then again, if you call them back to work and they say, well, my child's daycare is closed, then you may have one of the issues that Laura Scott talked about before under the Families First Act and the expanded FMLA and the emergency paid sick leave. I also want to mention that, those two laws are based on, obviously, the Fair Labor Standards Act and the pre-pandemic Family and Medical Leave Act. And both of those laws have individual liability. So your supervisors, if they interfere with paid leave, could potentially be a target for a lawsuit in addition to the company. So again, as we always tell people with family and medical leave, train your frontline supervisors, or at least have, during the time these laws are in effect, have one or two people that are specifically designated as the contact people for that kind of leave. So let's go to the next slide, please. So on this slide, you'll see all manner of the new normal. Democrats right now are fighting with Republican efforts for protection. Republicans are trying to get protection.
$500
liability lawsuits. Chamber of Commerce, they're fighting calls for new health and safety regulations. The unions are demanding worker protections against discipline if a worker feels unsafe at work. But almost every business is going to have to enact some of these measures for public health reasons, for employee safety reasons, and for public relations reasons. And it's smart to do so, especially in the immediate future. Inevitably, when you have people coming back to work, you're going to have some that are going to complain that you're going too far, you're doing too much, they don't like to be monitored. But it's really not those employees you should be most concerned about right now from a liability perspective. It's really the employees who don't think you're not doing enough, who don't see changes in the workplace, because all it takes is an anonymous phone call or an email to a state agency to cause you a lot of trouble. Just last week, we had one of our clients in the tri-state, the state OSHA personnel paid them a visit for alleged violations of social distancing in their lunchroom, the common area, and they were shut down. So it is happening, and all it takes is one disgruntled employee right now to cause a whole lot of trouble. So these measures on this slide are not only smart, but they can hopefully help you avoid some issues down the road. And think about having a COVID task force if you don't already, and having some employees on that task force so that they're involved and they can let other employees know what's going on as well. There's been a lot of talk about taking temperatures of employees and visitors. If you take the temperature of employees, keep in mind that this is akin to the donning and doffing cases. Do you have to pay for preparatory activities before people actually get to work, where they have to put on PPE or safety equipment? This is a pretty unique situation. Our advice is, if you have employees waiting in line, you're taking their temperature before they can get into the workplace, pay them for that wait time. You don't want to be the test case for this kind of issue. Next slide, please. Let's talk about the teleworking from home, which obviously a lot of us on this call are doing.
Hey,
Mark,
Mark.
I think you've muted.
I don't think, can you hear me now?
Yes.
Okay, sorry about that. You want to make sure that you are telling employees working from home that they are not to underreport or overreport hours. You may want to have, there are software safeguards that you can cut off their access to email at a certain time. But remember, even if an employee works unauthorized time, they still have to be paid for that time. They can be disciplined, but you got to pay them for that time. Also wanted to mention, if you have employees working at home that are buying office supplies and paper and maybe one of those ergonomic keypads, you should think about reimbursing them for that. Obviously, I know Illinois has a specific reimbursement law for business expenses, because especially if you have hourly workers purchasing business-related equipment and that dips them below the minimum wage, you could have some serious wage and hour problems. So keep that in mind as well. I'm going to go ahead now and turn it over to my partner. Mike Schottmeyer is probably one of the most civic-minded attorneys, not just attorneys, but people in this community. You would not even know what I-69 was if it was not for Mike Schottmeyer. And if you don't believe me, all you have to do is ask him. So I'm going to turn it over to Mike Schottmeyer now to talk about insurance.
Thanks, Mark. I knew when we organized 7 folks I've negotiated across from that we over and over for decades that we would go over. So we are over now by 11 minutes, probably be another 5 or 10 minutes, but I look and we have 85% of the folks on, so I'm going to move ahead. I'm going to talk about how you and your businesses can pay, recover, and shield yourself. This is all about money. This is 5 points. I'm going to make them pretty quickly since we're over by a little bit. 1 is you've got insurance. Number 2, you've got contracts and amendments. Number 3, you've got some additional tax credits on top of PPP and the other incentive programs we've talked about that'll be available to you, tax credits. Those are rare. Number 4, you've got waivers that can shield you. And number 5, you've got some workforce monitoring audit provisions that can shield you from all of these guidelines. There's what the CDC put out this week, and it came out of OSHA. And as has been alluded to by all my colleagues here, these are coming out fast and furious, and all of us are in webinars like this virtually every day because it's changing. Let's kick off in the first slide. You have it here, Audrey. Thank you. And Frank May, you asked a question about, hey, people are out there working or getting unemployment, the $600, and they won't come back to work at my business. I believe the provisions of the law, and this is not in my subject, maybe in the others, but if you offer them and you can come back to work, and let's assume the governor does that in all of our states tomorrow, and you offer it to them, then the $600 can go away. That's probably a good inducement to bring them back. So be aware of that. I know a lot of people are griping about it, but there are ways in which you can call them and say, look, you're going to lose your unemployment, maybe not all of it, but the $600 potentially. Insurance recovery, this is really important. We won't know how much money this means to all of our businesses. All of us have been advised of this by our agents, I hope. The drafting of the claims is really, really important. A standard claim form will not work. The claims have to be very broadly, really a lawyer-like ambiguous in how they're written. They got to be tendered in the right way. Tendering through your agent alone, an email to your agent, is not going to be adequate more than likely. The notice requirements are very, very, very precise in policies. And if you fail to do so and follow those requirements, certified mail, all different addresses they have to go to depending on the different coverages, then you're going to find you're going to get a denial. It's going to be a year from now, months from now, and then it'll be too late for you to file for the claim. You got to file your claims quickly. I think that when the governor's orders lift the COVID stays we've had, that you're in the next couple of weeks, you're probably approaching what might be a deadline to file. So get that done. But understand, even if you can't, as many clients have said to us and our team on the insurance claims, well, I don't even know what my claims are yet. You can always amend your claims. You can always amend them, so file them and get them in. Number 2, next slide. Couple items you're going to need is everyone's talked to on all the different programs, PPP, and this would apply to insurance. This will apply to your contract claims where you have change orders and different items, but I have it under insurance here. You've got to set up separate accounting for your mitigation measures. So you can't just say, oh, I had to pay all this additional sums, like Mark said, for new equipment for my employees at home, or working from home. But if they bring that equipment in and now they're able to use it in the office, well, then, that might be a mitigation factor you got to account for. Maybe not a good example, but mitigation is very important and it has to be documented. One thing that people don't understand in insurance claims, and we've recovered in the environmental field, in our environmental practice, lots and lots and lots and lots of cleanups that people in the 80s and 90s were told by every insurance agent, that's not covered, that's not covered, there's an environmental exclusion. Well, those exclusions didn't stand up at all under Indiana law. And we have to use a mechanism as lawyers called bad faith. And that's how you bring the insurance carriers around to reasonableness, to stop delaying, and to begin a settlement process. So setting up that bad faith process requires these claims to be right. And then finally, documentation of all these items I've talked about, the claims, the accounting, the so on and so forth here are going to be real important because there's legislation pending that's probably going to make these policies pay more than people think, as well as there's going to be a lot of third-party decisions that are coming out of the court. All of you've read the court cases are already being filed. We don't think that's a wise approach for our clients. Let somebody else do that, and we'll see what happens to the case law. Next slide, please. Contracts have many of the same aspects as insurance. You've got to locate those contracts. You have to begin with your suppliers, your customers, all of those people you have your major contracts with, like these policies. You got to begin to notice up what's going to have to change. We're going to need to mend these and work together. That's going to require, again, prompt notices. It's going to require that you consult with your accountant for the accounting, with your insurance agents, obviously. Document, document, document. Create these separate COVID accounts. We can't emphasize that enough. That partnership between your accounting firms, your insurance agents, and your law firms are going to be critical. We say that to any new business that's forming. We say, look, until you have an accountant, an insurance, or risk professional, you're probably not ready to start a business. Likewise, as you're working with a crisis like this, those three are really important to you. And then mitigation of losses and delays and damages, and disruptions, that needs to be done in conjunction with your customers, with a lot of communication and a lot of amendment of contracts that's going to be done. Next slide, please. There's tax benefits beyond PPP and their tax credits. And those are all the leave that my colleagues have talked about before that are now mandated for all of us as small businesses, and large businesses always had those leave requirements. But now all this added leave and many of our, particularly our employees who had children at home when the schools were closed, we've had to offer a lot of unpaid leave and paid leave in many cases, and you're going to get a tax credit for that. Let me skip through this slide, but the point is that credit, if you don't think you qualify for PPP, that credit may be worth hundreds of thousands of dollars as well to many of us, and you have to take one or the other. You can't take PPP and get these credits. So for those who don't receive the PPP or decide they don't qualify, there are some, under the tax code, tax credits, which are not deductions, these are credits. Next slide. Here's the limits on them. It's per employee, roughly 15 grand. It also covers the health insurance benefits you're paying. Next slide. One issue that's coming up a lot the last week as we look at coming back to work are particularly with our beauticians, independent contractors, barbers, those who work in massage therapy, any business where in particular the social distancing is impossible, they're asking about waivers. And if you will email me, I will send you a waiver form that might be workable or usable by your business. We've used them a lot in the field of sports for decades. So you may, if you will email me, I'll send that to you. Here are the pros and cons. I won't go through them. I think most people will decide not to use them. But I think on those businesses where you're actually having to touch the customer or the client, I think you will probably want to look at one of these waivers. And then finally, what we're facing here is a lot like TARP, which we had in the Great Recession. It's a lot like we faced when Superfund was enacted in the late 80s, early 90s, when strict liability came in place. We're going to need to be able to meet all of these guidelines that are being cast at us right and left with our companies. We're going to need to do some monitoring. In fact, in some of the Department of Labor requirements, particularly for meat packers, monitoring is required. We're going to suggest that if really everyone has their employees' interests, it's the number one interest for them, and many people are saying that for sure, that, oh, it's number one to us is the health and safety of our employees and our customers. Well, if that's the case, I'm going to suggest to you that you're probably going to want to do some compliance monitoring. We've done that in the environmental field for 20 years. We helped enact in Indiana an environmental audit statute, 1328.4. It's cited here on this slide. That's a tool that you'll be able to employ with, preferably with your lawyer, by hiring a company to come in and do compliance monitoring on all these new standards. You saw the list that Mark McAnulty had in his material. So this is a tool, and if you use it correctly, could provide for a defense or a shield, just like these waivers can, for your company down the road if something comes up or if somebody begins to pursue you. there's going to be enactments, we know, that are going to shield folks from liability. Everyone's demonizing our trade right now. And first of all, it's going to be very, very hard to prove where someone received the COVID virus. I think the cases are not going to be as prolific as some are threatening, but that's also said that there's going to be some enactments of some safe harbors. And if you follow what we've talked about here, you're going to fit in that safe harbor. And here's another tool. If you would do one of these environmental audits, then and it comes out clean, of course, and if it doesn't, you'll make adjustments, then I think you'll be protected. So with that, Tara, I think we've covered all of our materials, I believe. I'll be happy. We've answered a couple of the questions. I don't know if we can answer them all. We're over by almost a half hour now. So Tara, you tell us what to do.
I always like to hear an attorney tell me that I can decide what to do. In all seriousness, thank you. That so much great information, and I think everyone that's on this call would say an hour and a half is still a drinking through a fire hose, but we have found this extraordinarily helpful. I think Mike made some extraordinary points about the importance of relevance and the importance of not just these professionals, but your professionals in the accounting, insurance business. Those that advise you in your business are extraordinarily crucial to the decisions you're making now. I'm going to suggest, with respect to the people that have submitted questions, that we direct them back to you all one-on-one, which we can do because we've copied this chat, so we've got those, if that's acceptable to everyone. We are also going to make this communication and the slides available to everyone on the call, so I think we'll have the opportunity to loop back. You can see right now the presenters are on the screen in front of you. But just to follow on Ted Ziemer's comment, stay on top of it. How can you do that? One good way is to stay on top of the Chamber's website. We have pivoted all of our content to drive it to supporting the business community's needs right now. So we love it if you're a member. Right now, we're really most interested in making sure every business in this region has access to current information. So we'll keep the latest guidance from the governors here. We'll keep it accurate and current. And we know from surveying you all that making sure your employees are safe, making sure your customers are safe, and making sure your customers are confident are your key priorities right now. So as we get this guidance, which we expect very soon, we'll put tips here and useful information that help you get your business prepared to reopen in, I'm going to say, a cost-effective manner. I had the opportunity to tour Toyota this morning, and that is a massive international operation. They are doing so much of their work and their protective planning with materials you can get at the hardware store. So we're trying to bring some of that information to you and make sure that you've got ways that you can begin to set up your work environment so you're prepared for the reopening times when it comes. But that's only one aspect of getting open. Most important is making sure that your business is safe, that your employees are protected, and that you use these opportunities that the federal government has made available to all of your businesses properly. So I think that the information you've shared with us today is crucial to us doing a good job as employers in this region in moving through this next transition. It's going to be new information every day, so we will keep you in current. The folks that are on this call, every one of you is important to this region, so thank you for investing time for your business in this work. And thank you for all of, as Mike said, those people in your trade that are sometimes the butt of jokes. We couldn't be more respectful of the time you've contributed and the support you provide for this community. So thanks to all 7 of you and all 4 of your firms for this time. And to everyone on this call, know that the future planning for your business is our top priority as a Chamber of Commerce, and on behalf of my business partners with the coalition, our local governments, our cities and counties, we are all front and center making sure we can provide you with the most useful tools out there. So I'll wish you all a good Thursday afternoon. I will express my many thanks once again to all of you talented professionals that have made your time and your expertise available to us. I think it's been an extraordinary webinar, so thank you all.